satisfaction that the academics of the country are in a position today to play such a vital role in creating public opinion and in impacting on public opinion. Just about 3 to 4 years ago, I think all of you would agree that Futa was quite an unknown entity in the country. And there was widespread discontentment about the role of academics in society. There was a sense that we are not participating in public life, we are not providing information to the public, we are not sharing our thoughts and ideas. And when I look back at the path that the academic community has taken in the past, just the past 2 years, and today we are here discussing this extremely vital issue with the media, I think we have come a very long way as a community that is very important in a democratic society. And the fact that, Futa, which engaged in a 100-day-long strike, speaking about and advocating the right to education, today is presenting these ideas and sharing thoughts and ideas with the public on various public issues, is really a sign that we've come a long way and that at a political level, the academic community is really maturing. During the Futa strike, as our president, Dr. Devasiri pointed out, we raised issues about the right to education and the various issues pertaining to the right to education, more allocations for education and so on. But one of the very major points that we pointed out during our strike was that the objective of education must be viewed essentially within a democratic framework. It must be education to preserve democracy, to preserve the rights and liberties of the people, and that the objective of education should not be limited merely to creating employees for the job market. That there's a much more profound and fundamental objective of education, and that is to create full people, full personalities, development of personalities of the youth of this country and others, and democratic citizenship. That is very, very important. So today, as we speak about this very almost unprecedented crisis that we have entered into in this country, and sadly, after ending a very tragic, almost 30-year-old war, that we have to speak about these issues is tragic, but at the same time, it points to quite a number of the issues that we raised during our trade union action. So there is really no division or disjuncture between what we discussed then during our trade union action and what we are discussing now. There is very much a very clear connection between what we discussed earlier and now. Now about this very critical constitutional crisis that we are facing today. We have to recognize that we are at a very crucial crossroads. ඉතාමත්ම බැරෑරුම් දේශපාලන සංදිස්ථානයකට අපි පිවිසලා සිටින්නේ. ඒක අපි කොහොම තරේ පිළිගන්න ඕන. If this crisis cannot be resolved and will not be resolved according to the rule of law, according to the constitution, the harm that it will cause the people of this country is irreparable. That has to be recognized. You cannot look at it purely from the point of view of the written law, etc. Of course, we have to focus on the law, but we have to first of all, foremost, recognize that this is going to harm the people of this country. And it is from that perspective that this impeachment saga has to be viewed. Now, we as students of law, we as academics who are training young generations of students who are to be lawyers, don't see anything wrong with the impeachment as a method of disciplining members of the judiciary. That is a method that is used in almost every democratic system of government. We know that democratic systems of government must have the systems of separation of powers and checks and balances. And impeachment of judges is a very important check that democratic societies incorporate into their supreme laws. But the problem in this country today is whether this very acceptable form of disciplining errant allegedly errant judges is being used in a democratic spirit. මේ දෝෂාභියෝග ක්‍රියාදාමය ඇත්ත එහි අපිට ප්‍රශ්නයක් නැති වුණාට ඒ පිළිබඳව ඒක ආණ්ඩුක්‍රම ව්‍යවස්ථාවෙන් දක්වලා තියෙන ක්‍රියාපටිපාටිය ක්‍රියාමාර්ගය නමුත් ඒ භාවිතා කරන ආකාරය පිළිබඳවයි අපිට මේ ප්‍රශ්නය ඇති වෙලා තියෙන්නේ. So we are wondering why all of a sudden an impeachment motion was brought against the incumbent Chief Justice of the country. If, as alleged in these charges, the 14 charges, the Chief Justice is guilty of various forms of offences that was known for months, why at this juncture was the impeachment motion brought? As Dr. Devasiri pointed out, there clearly is a politicized environment in which this impeachment motion has been brought, and this is really not in the interests of the public. Definitely not. And it is very clear that this is for very narrow political gains that this impeachment motion has been advanced in Parliament, and that is the the first point that has to be raised. And then we saw how in the procedural dimension of the impeachment motion, when the Parliamentary Select Committee was appointed by the Speaker, we saw the serious problems that plague the entire procedure. First of all, the way the numbers in the Parliamentary Select Committee, 7-4, 7 members from the government side, 7 MPs from the government side, and only 4 from the opposition, heavily weighted towards the government side. And we all know, given our political culture, that MPs do not function on the basis of their own conscience, but they toe party lines. So that 7-4 number is extremely problematic. Secondly, there is a serious question of denial of the protection of natural justice to the accused, in this case the incumbent Chief Justice of the country. Was sufficient time given to her to build up her defense, to present her defense to the Parliamentary Select Committee? At the same time, was she informed of the procedure, the evidence, the burden of proof, etc., the procedural dimensions that are very important to anybody who's accused of offences? Those were not, in our opinion, afforded to her. In fact, after being, as it is reported, in fact, after she was informed that no oral evidence would be conducted, and then thereafter various, events, she left the Parliamentary Select Committee. Then we are told that a number of witnesses were brought before the Parliamentary Select Committee, and their evidence was recorded. By that time, the Chief Justice had walked out, and at the time she had walked out, the information we have got is that her legal team had been informed that no oral evidence would be conducted. But after she walked out, oral evidence was conducted by calling several witnesses. So we are extremely dissatisfied with the procedure followed as well. First, we are dissatisfied about the environment and the manner in which the impeachment motion was introduced. And secondly, we are extremely disturbed by the procedure followed in investigating the charges made against the Chief Justice. Now we have come to a point where there are several cases pending before the Supreme Court and the Court of Appeal, especially the Court of Appeal. We know that 2 judgments have been rendered just a few days ago, one by the Supreme Court of the country, the highest court of the country, and yesterday we understand that the Court of Appeal also has issued a writ of certiorari quashing the finding of the Parliamentary Select Committee. Now we are also told that the decision has been taken that Parliament is not going to abide by these judgments. කියන්නේ මේ උපරිම අධිකරණ වලින් දෙන ලද තීන්දුව අනුව කටයුතු නොකරන බවට පාර්ලිමේන්තු තීරණයක් අරගෙන තියෙන බව අපිට පුරවැසියන් හැටියට දැනගන්න ලැබිලා තියෙනවා. දැන් මේක ඉතාමත්ම විශාල අර්බුදයක්. This is extremely problematic. Now the reason that is being given to us as to why Parliament will not follow the Supreme Court judgment and the Court of Appeal judgment, as we understand it, is that Parliament is supreme. Therefore, Parliament is not under an obligation to abide by the decisions of the Supreme Court and the Court of Appeal. This is absolutely wrong. This is absolutely an illegal position. With due respect, it has to be pointed out. Absolutely against the constitution of the country absolutely against the rule of law of the country. In our scheme of government, which we say is democratic and socialist under the constitution, nobody is as supreme as the people. ජනතාව තරම් උත්තරීතර ජනතාව උත්තරීතර බව එහෙම නැත්නම් පරමාධිපත්‍ය තරම් වැදගත් සංකල්පයක් මේ රාජ්‍ය ක්‍රමේ නැහැ. The people are supreme, the people are sovereign, and it is the constitution that is supreme in the country. It is the supreme law of the country. And where the parliament is concerned, or the judiciary is concerned, or the executive is concerned, all three branches of government, their powers are limited by the constitution. We all know that, and that is a very fundamental feature of democratic governance. That is limiting the excessive powers of any organ of state, whether it be the executive, the legislature, or the judiciary. And all three organs of government are exercising not powers that are inherent in them, but powers that have been conferred on them by the constitution via the sovereign powers of the people. So all three organs of government are repositories. They are repositories of people's power. එහෙම නැත්නම් මේ අහඹු ලෙස ඇති වුණු බලයක් නෙවෙයි මේ රාජ්‍ය අංශ තුන ක්‍රියාත්මක කරන්නේ. නමුත් ජනතාවගේ පරමාධිපත්‍යයෙන් ලැබුණු බලය තමයි මේ අංශ තුනම ක්‍රියාත්මක කරන්න එක මතක තියාගන්න ඕනේ.